Good afternoon, everyone, and welcome to our annual Emroch lecture at the University of Richmond School of Law. Special welcome to our alums who are joining us. It's always wonderful to have you back and have a reason for you to come and connect with us again. The Emroch lecture series provides a unique opportunity for us to hear from thought leaders in the legal community and beyond, and to engage in meaningful, sometimes controversial, conversations about important topics. Today's event is made possible through the generosity of the family of Emmanuel Emroch. Unfortunately, they were unable to join us today, but we're very grateful for their support. Just a brief word about Mr. Emroch. He was a 1931 graduate of the law school, had a very distinguished career as a trial attorney, but also was noted for his commitment to anti-discrimination efforts in Virginia in the 1950s and 60s and 70s. There was a lot of work that needed to be done then. There's still work to be done. But he was noted for those efforts and was founder of the Richmond chapter of the National Conference of Christians and Jews, and received their humanitarian award in the 1970s. So he stands as a model of what an outstanding trial lawyer can do beyond the courtroom, and I commend him to you as a model. So now let me turn things over to my colleague, Dean Allison Tate, who will introduce our speaker.
Great, thank you, Wendy, and thank you everyone for being here. We are absolutely delighted to have Professor Pistor here today as part of the Emroch series, and we're lucky to have her. She's the Edwin B. Parker Professor of Comparative Law at Columbia University Law School, and she's a leading scholar. She writes about corporate governance, money and finance, property rights, and comparative law and legal institutions. She's the author or co-author of 9 books, including her most recent one, although not the forthcoming one. Her most recent one is The Code of Capital, How Law Creates Wealth and Inequality, which is a great book about how law codes various assets such as land, debt, business organizations, and even knowledge to transform them into capital through contract law, through property law, collateral law, trust law, corporate law, and bankruptcy. It was named one of the best books of 2019 by the Financial Times and Business Insider. Today she's going to talk to us about the law of capitalism and how to transform it. And this is material that's from her forthcoming book, which is about just this, which is forthcoming hopefully this fall, I believe, with Yale University Press. So without further ado, I will turn it over to Professor Pistor and let her tell us about capitalism.
Thank you so much for this kind introduction, and thank you all for coming. It's a great honor for me to be here in Richmond and deliver the Emroch lecture today. So as was already announced, I'm just in the process of proofreading and getting the book and making decisions about the design of the cover and all these things, and finding an indexer for the book, The Law of Capitalism and How to Transform It, which is a book that is kind of part of a conversation I'm having with colleagues who have launched the law and political economy movement around the time when I was basically closeting myself and writing the Code of Capital. That emerged at the same time, and we kind of found ourselves. And they were wondering then whether I would be willing to write the first in a series of books that are supposed to provide kind of a theoretical foundation, loosely said. So we don't have all the same ideas about how to think about law and political economy, but we have different approaches, and we explain them in these different books. So that brought me then to the law of capitalism. So the book is really, it works, it's organized around a puzzle that I posed myself. And the puzzle is as follows: why is capitalism, a system that is coded in law, as I explained in my previous book, so resistant to legal constraints? So if it's made of law, why can't we capture it? Why can't we contain it and direct it through law? What is the explanation for this? So just a word about the previous book, because that's kind of the argument on which I build here. I do say capital is coded in law, so as has been mentioned already, the simple equation is give me just any object, any idea, any promise to future payment or something like that, and with the right legal institutions I can code this as capital, capital being defined as an asset that has the capacity to generate and protect wealth. So I'm saying you always need something, some stuff, some asset, but without the legal coding it's nothing. A piece of land, you can graze your cattle, you can go picnicking and whatever, but you can't extract money from it unless you have a legal title. The same is true for ideas. You need a patent, you need a copyright, otherwise other people can take it, and you can't keep for yourself the returns on these assets. So coding, the legal coding, is about monetization. It's extracting the monetary value from an asset, and that's, of course, key for capital. So when you think about this, you have basically a system where you can code capital. Sometimes people get overboard. They just want to have a lot of money. They want to become very rich. They take risks that might be harmful for society, and then in response to major financial and economic crises, we typically try to put some rules and regulations in place to make sure it doesn't happen again. So the biggest event, I think, of a major crash to which law then responded were the financial and economic crisis of the 1920s and 1930s. In the United States, already during the New Deal, a lot of new regulations and laws were put in place. In Europe, most of this happened after World War II. So after World War II, I think there was a general understanding that we have to kind of contain the powers of capitalism to make sure that at least people can participate and it doesn't create the kind of crisis that can bring entire societies and their political system to the abyss. So capital controls were put in place. Financial regulation that later was labeled again financial repression was put in place. New labor laws were created, individual but also collective labor laws. The welfare state, social security was created to make sure that people would not be despondent and thereby vulnerable to political attacks, and the broadening of access to justice through the reforms of the Civil Procedure Code in this country in the 1930s, but also similar reforms in other countries in Europe after the war to make sure that not only the well-resourced, the wealthy had access to justice, but people more generally would as well. Now, what I'm basically saying, what is interesting, you see these major efforts, and then you see also that slowly but surely they quickly erode. So over the 20, 30 years, many of these things are not completely eroded, are not completely gone, but they have been weakened. So we get the avoidance first the avoidance of capital controls through private law coding strategies. So you give me capital controls, I do a currency swap. You give me restrictions on the kind of financial intermediaries that can engage in banking activities. I invent shadow banking, which is basically a way of sort of disentangling banking activities through multiple legal structures, a more decentralized way, etc. So when you just look very closely at the micro-institutional evolution of how capital gets around these constraints, you find that even before a law is adopted that says now we are done with Glass-Steagall Act, or we're now sort of removing capital controls or something like that, very often the grounds have already been laid through coding strategies. So I'm basically saying the post-war legal order that was trying to tame capitalism slowly but surely fell apart over a process of 20, 30 years, right? So that's just an observation, and then I'm trying to explain more details why this and what the mechanisms really are that make this possible. I think we can say something similar about the response to the financial crisis of 2007, 2008, which was never as reformist or transformative as I think the reforms of the 30s or the post-war era were, but nonetheless, even when we think about the financial Stability Board that was trying to really set the norms. They were, I think, quite successful with banks. They were never that successful with non-bank financial institutions, and that's, of course, where much of the activity is. So again, we're just putting things in place. We're putting stress tests in place, and then, of course, the threshold for stress tests will be reduced. And so the pushbacks are always there, right? So you can't really easily maintain this. And so you can say this is all politics and power games, and that is kind of true, but I'm also interested in the mechanisms, especially the legal mechanisms, through which these power struggles are actually being carried out. So before I go into my own argument, I just want to highlight a couple of authors who have influenced my work and their own conception of what capitalism is. One is a German author, a sociologist, a political sociologist, Wolfgang Streeck, who basically says capital is accumulated in the hands of minority who enjoy the legal privilege of private property. Now that's a Marxist type of definition, doesn't really capture the complexity of the law, but I just wanted to throw this in here. I think an interesting dimension for capitalism that I also would embrace is Hyman Minsky and Keynes before him has said something similar. It's basically that capitalism is essentially a credit-based financial system. It's a financial system. It's not only about production. That's also why only thinking about property rights is probably not entirely correct, but it's really much about finance and the structure of the financial system. Then Geoffrey Hodgson, an economist from the UK, he has written a book about reconceptualizing capitalism, where he basically says we have to understand the legal institutions that create capitalism. So our ideas converge there a little bit, but I think in my view he was a little bit too encompassing of the different legal institutions, and didn't boil it down to a more refined system of capitalism, which I'm trying to do in this new book. I'm not sure I will succeed. And then Jonathan Levy, a historian from the University of Chicago, is now moving to Sciences Po, but he basically said, similar to Hyman Minsky, that investment, not production or exchange or consumption, is the first mover in capitalist economies. And I think that's, again, important to realize. So my conception of capitalism is that capitalism is a legal regime. Taking seriously the notion that it's about investment, about the future, I'm basically saying what we're trying to do in a capitalist system is to monetize or realize our expected future returns. So yes, we make an investment in the future, but we would like to trade this stuff already today because we want to have access to liquidity and money and build our wealth already. So that's actually a very complex and rather challenging goal to say there's some uncertainty in the future, we're making bets in the future, but can we do something that we can actually trade this already today or realize some of the returns already today? That takes not just a village, I'm saying, but that takes a state, its legal system and its money system. So essentially capitalism in my world is a system whereby private actors can use critical social resources, because I think the legal system is a social resource, the money system, the monetary system is a social resource for their own ends of producing private wealth. Right? And so that system I need to explain, and then I need to explain why the system can actually resist the kind of legal constraints that we've put in place time and again after major financial crises. In order to make that next point, I basically went back and read a lot of literature about what is capitalist law. And just to make that point, most of us, when we teach law here in American law school or even in German or European law school, we never ask whether the law that we teach is capitalist. We just say that's the law. We did make a nod to different types of legal systems at some point. When the socialist systems were still around, we always talked about the civil law system, the common law system, but rarely asked whether these are capitalist or what might make them capitalist. When the socialist system had been around for quite a while, people said we have to incorporate them into the families of legal systems, but once the socialist system had basically gone away, largely, we also scrapped them from this again, but stopped asking the question. So I really had to go back into the 1920s or even earlier to find authors that had seriously engaged with the question, what is capitalist law, what is socialist law? And here's one, is Yevgeny Pashukanis, who was the leading legal theorist in the early Soviet Union. He was executed by Stalin, but he was influential in the 1920s, as were many others. There were vigorous debates at the time. And one important point he makes is for him, it's really the legal form that makes capitalist law capitalist, not just the contents, but it's the legal form as such, typically organized in these sort of private law claims that are enforceable. And then even more importantly for my argument in my book is that he says capitalist law is basically essentially a legal system that brings two different forms of law into one, or lives off the antithesis of two legal systems that struggle with one another. One is the public, the other is private. He resists a little bit the argument that you hear a lot from legal realists who always say all law, of course, is of the state. So in the sense, even private law is public law. He actually says in his book, you could just as well say that all law is essentially private, because when you go back to the Roman roots, that's where it comes from, right? But he says what happened with capitalist law was like a division of two different legal systems based on different foundations, and the struggle between them explains, at least in part, how the system operates, and I will say a few more words about this later. He did not like Karl Renner's argument. He had written an earlier book where he basically said, you can have the same form, the same law, and you just fill it with different contents depending on the underlying economic conditions. So this is, again, a classic materialist Marxist position saying what really is important is the underlying historical materialism, and then you just put this into different forms, and you can fill different forms with different contents. And Pashukanis made fun of that and said that's just too simplistic. We have to understand more the intertwined relationship between public and private law. So what is kind of interesting to me is when in contrast to these debates of the early 1920s, you get in the 1990s sort of also an attempt to talk about our legal system without necessarily naming it capitalist, but being very explicit about what the functions of this legal system ought to be. And that is the maximization of returns to investors. So that's only about the monetization of future returns. The law and finance literature was spearheaded by Andrei Schleifer, and of course Raphael Laporta is always the lead author because he's first in alphabet, but I think it was Andrei Schleifer and Robert Vishny really who launched this entire literature, who basically used empirical methodologies but based on their own understanding of what the law should deliver to suggest that countries or systems that have better protections of individual investor rights have better developed financial systems. They were never able to prove that they also have more growth. But there are other studies that suggest if you have a good, well-developed financial system, you might also have more growth. But they always stopped short of making this second leap, but you have better finance. And if that's what you want to have, then you have to have very strong investor protection. In their regression analysis, they found that common law countries, by and large, have much better protection of shareholders in particular. When it comes to creditors, the German-style civil law systems are almost the same, but the French still suck. So they don't have very strong creditor protection. So they do concede in their original paper of 1998 that, after all, France is a pretty rich country. So even with less effective creditor provisions, it can become rich, a puzzle that they don't completely resolve. Almost the same group of authors now added Simeon Jankov, who was for many years at the World Bank. I think he's back there now. He had a stint as a finance minister of Bulgaria. They tried to explain the origins of these different legal systems, the civil law and the common law, and they said it's ultimately the politics that shape legal systems. So if you have the Norman conquest in the 11th century in England, and they can't really control everybody, they do have except some decentralized dispute resolution in the form of juries, and so you create a system where you leave a lot of power into local hands, and that, they suggest, also enhances the idea that you will protect individual property rights in these communities. Whereas in France, you always have the battle over even trying to control the entire system, and once the king, the emperor, was able to centralize control, then he dictated the law. That's their story. I don't think that's necessarily the true history of civil law and common law. I'm just mentioning this here because you get a little bit of a sense of what they're trying to say, and that, I think, is consistent also with some of the arguments that Pashukanis made. It is really, the question is, what is your center of attention? The decentralized legal system rooted in private law to protect individual investors, or a more centralized system that thinks about public law and the state? And then, of course, the question comes up, what is the relationship between the two? So now I want to develop my own argument. So I'm basically saying, again, capitalism is a system that mobilizes social resources, the legal system, the money system, to create private wealth. The foundations of this capitalist law, or the premises of this capitalist law, is that we have this duality of two legal orders, public and private, as I just explained. I think it's also interesting to note, in passing at least, that historically speaking, capitalism preceded democracy, right? Capitalism was there first, then came democracy. Capitalism built around the institutions of private law that also preceded the nation state. when the modern nation state came about, it did not question the existing private law. Some countries would codify it, like France did or Germany did it later, to create a national legal system, but they didn't fundamentally alter the principles of this legal system. In fact, the constitutions, to some extent, also reinforce the rights that had been created before, because we created protections for property rights and we have the sanctity of contract. So whatever private law system had evolved gets additional fortification, if you like, within the constitutional systems that were created later. And then quite important for my purposes is that I think this history, together with also like an ideology or culture or preferences of people, creates sort of preferences for private self-ordering over public or collective ordering. And that's basically ingrained in how the system operates. So based on these foundations, I think the capitalist law, if I want to say what are actually the mechanisms that help the system to reconstitute itself, regenerate itself time and again, even if sometimes one pushes it back, there are three features that I think, historically, comparatively speaking, are quite important. First, that the system empowers private actors, legally empowers private actors, contract rights, private property rights. Sort of a lot of rights and legal structures that we create that allow private actors to be actually quite powerful, not only vis-a-vis an object, but vis-a-vis others through this object as owner or through the contracting. And to some extent, of course, the contracting power has been enormously expanded in recent decades. The second feature is that, yes, a state is very often defined as the institutionalization of the means of coercion, so the state centralizes the means of coercion, but access to the means of coercion is available in a highly decentralized fashion. We call this litigation. So who can litigate, on what grounds, and whether individuals or collectives can bring cases, and what rights are justiciable are all questions that we deal with in civil procedural law. We never really think about this as capitalist as such, but I think it's worthy reconsidering at some point what kind of claims do we actually exclude from easy access to the courts. But the ability to be legally empowered with private rights and entitlements and mobilize the state's means of coercion to protect these rights is a very powerful mechanism to protect and to advance one's own interests. And then last but not least, what I call legal arbitrage very often goes under the name of regulatory competition or regulatory arbitrage, which is basically saying, of course, every legal system has gaps, so you can interpret it this way or that way. Most legal systems have multiple layers. You have local law, you have state law, you have federal law. At the transnational level, you have domestic law of one country, domestic law on the other country, and then you have conflict of law rules. And if you really know how to play the game, then you can actually pretty much pick and choose the law by which you wish to be governed. And if you know how to do this, then you have a much more flexible, because you can opt out of law that constrains you too much and opt into legal systems that offers you exactly what you want to have without losing the legal protection of enforceability even within your own jurisdiction. So in order to explain again my puzzle, the puzzle was, how is it that a system that is coded in law is so resistant against legal government? I'm basically saying, if you understand the logic of capitalist law, you have to understand that there's a lot of private legal empowerment, that you have access to the means of coercion through litigation. And of course, through litigation, you can also alter the meaning of the law. And if you are a repeat player and a long-term player, you do litigate not just for one specific case, you litigate for the rules. You're in this game for the rules, as Mark Gallanter has already pointed out in the 1970s. And if you add to this the legal arbitrage opportunities of picking and choosing, of interpreting this way or that way, then actually you have a lot of creativity to reconstitute capitalism within its own systems, within its confines. So I want to say just briefly a little bit of each of these features, so you get a little bit more of a sense of the substance of the book. So, of course, property rights are the classic way in which you can empower private owners vis-a-vis others. I can exclude others from using my own stuff. So it's not only my control over the stuff, over the object, over the land, the house, the machine, or the financial assets, but I can exclude others and I can claim the financial returns. Of course, we have built into our liberal maybe capitalist legal orders the idea that formal equality is more important than material equality. So we insist on formal equality. And of course, we realize that bargaining power makes a huge difference. And the way that has fed, especially, I think, into our contractual relations is something that is debated in the literature. I'm not saying anything new, but if you have the bargaining power to have standard contracts, and the standard contracts have mandatory arbitration clauses, and the standard contracts have other features, that is basically a take it or leave it option for the side, for the contracting party on the other side, there's not really any bargaining happening. Neither do we bargain when we click agree on the internet when we enter a platform. We just accept the terms that are being offered to us without a real viable alternative. So if you want to be in social, you can choose maybe between 2 or 3 different social media, but essentially you have to agree to share your data if you want to participate in them. So behind, of course, the mantle of formal equality, there's a lot of material inequality, and but by insisting on the formal rights, those who know how to use the system can use it to advance their private power. The other aspect I already mentioned is about litigation. The decentralized access to the means of coercion is it's highly individualized rights-based. So if you have other concerns as groups, as collectives that are not accepted to this desirable rights, then you have an issue. We have differential access, of course, to the courts. We also have to limit access to the court. That makes perfect sense, but I think the question that one has to ask is who has access and who does not have access. Standing rules are relevant here, and I think also in this country the fate of class action suit. So class action suit was supposed to be a means by which people who wouldn't have the resources to all go into litigation to band together and do this. And of course there has been abuse of class action suits. So I teach corporate law, and I know in securities legislation law even more so, but at the same time we also see a very strong pushback against these kind of mechanisms in recent decades, and I think we should be wary about that. And then, of course, there's the big problem of access denial, de facto or de jure. De facto because the courts are overwhelmed. Societies don't invest in state courts. People have to wait for years to have small claims represented. Colleen Shanahan, who used to be at Columbia, now went to Penn Law School. She's a clinician, but also a researcher on civil procedure issues. She did, with colleagues, big studies just showing that most people in small claims, they don't even have a lawyer. And in adversarial proceeding, that's a real issue because we can't really resolve these problems. So when we think that we are operating in a legal system, we assume that everybody can enforce their rights. But in fact, of course, they can't, because it would take a different type of investment to make sure that everybody has access to the courts. So then again, we have to think about who does and who does not, and how are the courts then being used by either side. And then finally, with legal arbitrage, I said most of these things already. So you can, if you are artful and you know what options you have, you can play with different legal systems, right? And you do this whether it's basically, offshoring things, whether it's tax avoidance, whether it's finding the best corporate law for your shareholders, so you can pick and choose. Forum shopping. Is one example of it, as is, of course, a choice of law. I use a term from French authors who basically talked about a bricolage, a kind of a do-it-yourself legal system that you can pick, that you can put together yourself if you have the resources, and of course that varies. So putting it all together, you can basically see how private law, in its interaction with public legal devices, because of course the courts in a way are part of the social legal system. The legal system as such, its credibility, its legitimacy, its operation is sort of a collective, a social resource, but how through the invocation of private law rights together with also the principle of private autonomy, we endorse these rights, you can create actually pretty phenomenal private power bases in societies that otherwise are organized as democracies. So I've just put here just a plug actually for my next book, which I'm already working on, which is called Coded Power. This is why I put the little C behind it. I didn't want to have my co-author come after me saying you shared it already. In that book, we're basically trying to develop the concept of coded power, and essentially saying if you control the means by which others organize their lives, you have enormous power. And that's the parallel that we draw between law, the way in which I explain how capital is being coded. If you know how to use private law to do that stuff, you have actually quite some power. In the digital world, it's probably even more extreme. If you control the algorithms by which people communicate, share their lives, go shopping, whatever they do, you have a degree of power that we have rarely seen. And the beauty of it is that we don't even feel it so directly. We feel it only indirectly. But what I want to say for the purpose of this talk only is that legal power is a form of coded power as well, because if you know how to code and if you know how to play with the different legal things, then you can create outcomes, good outcomes, bad outcomes. I'm not saying it's per se bad, I'm just saying we have particular structures in place in which this has been used primarily for the coding of capital, for the creation of private wealth, and I think we just have to concede there's also a lot of private power. So in private law, we rarely talk about power except for market power. And then we think that competition is the antidote. But there's also true power over others, of course over labor, that's Marx's point, but in the digital world over consumers. And so we have to think more about those aspects as well. So to me, the system is problematic for many reasons, and people can disagree. Some might think this has wealth. That there simply is no alternative, as the German Chancellor Angela Merkel used to say, and many others, Obama also, there's just no alternative to this, we have to do it. And of course the no alternative comes in part also from our frustration with the former socialist system and the simple fact that it collapsed. You know, I studied the socialist system in the 1990s. I spent a lot of time doing research in Russia. It's not a system I would like to recreate, just to be clear about this. Which does not mean that I therefore have to endorse the capitalist system. So coming from Germany, when we in West Germany critiqued something back home, they would basically say, well, why don't you go to the other side? You know, just leave. The point is that I think I would like to create a better world. So this is where I come from. I want to say, if I want to move beyond capitalism, I, for example, do not want to have a centralized state or centralized planning. I think there's value in decentralized decision-making. The question is how we can do this in a way that doesn't create this entirely skewed system that we find ourselves in today. So, of course, many people have thought about how to move beyond capitalism, what to do. Going back to Marx again, revolution was the choice, political struggle and ultimately revolution. Andre Gunnar Frank, who wrote about developing countries, Latin America in particular, he actually made the point that we need fundamental structural change. So the emerging markets, developing countries, they didn't call them emerging markets back then, but the developing countries had to opt out of the capitalist system back in the 1960s. And he conceded that that the relationship between the periphery and the center has changed since colonialism, that there were changes. But he said the structure is always the same, still periphery and center. And he downplayed the role of institutions because he said the institutions change all the time, but the structures remain the same. My focus, by contrast, is always on the institutions and their replications and the logic of these institutions, because I think the fact that they are malleable is so powerful. And saying that they change is not an argument against the fact that actually much of the work is being done in a decentralized fashion by institutions and by people who operate them. And then Wolfgang Streeck, whom I've quoted before, he basically has a book about how capitalism dies, and he describes like its endogenous decline, a long period of demise and crisis, like the Middle Ages, entering the Middle Ages, and then something will come out of that. And that might be true. That's, you know, this doesn't sound wrong. The question is whether if we want to have change and we have particular ideas of where we want to go, whether we have any influence in trying to shape this rather than just wait for an interregnum. So that then brought me to John Paget, who is a sociologist at Chicago, also involved in the Santa Fe Institute, who has studied many transformations historically in Italy and the Netherlands. And one of his most, I think, powerful insight, at least for me, has been that you can see actually transformative change in societies. Major transformative change that is not just a revolution where you just change the people at the top, but transformative change typically when you have multi-layered institutional change, when in society, in different social domains, similar processes of change happen at the same time. And the one argument, example, and let me just go back to the example that I also refer to in the book, is his depiction of the Netherlands at the cusp of their famous Gilded Age in the 17th century. They were governed by Spain, Catholic, centralized rules, suppression, and within a period of 50 years, including, I have to say, violence and civil war and civil strife and religious war, all that. But within a period of 50 years, what emerged were the general estates of the Netherlands, decentralized governance structures in government, federation, a new church, the Protestant church with decentralized structures, and the birth of the corporation, which at that time was basically in non-market, or it was a mercantilist invention, but it was a new form of doing business, which of course in our own age has become a major force of centralized power in many ways, but in that context was a new way of doing business. The major point is here, I think, we don't know if what he says is true. It might be true not only for creating capitalism, but might also be a strategy for thinking beyond capitalism. The point is that change has to come in multiple layers of society and has to be, it's very often is incremental. We might not even see it at the beginning, but if many do it, we might get a little closer. So if we think about legal transformations in history, there are different examples. I don't want to go in too much into them, but I think there's truth to this idea that we actually don't necessarily get the most transformative change just in a revolution. So if you think about the French Revolution, within decades, according to Thomas Piketty, France had the same level of inequality that it had before. Yes, it was a republic, then monarchy even come back, right? And you get back into inequality. So what really changed underneath? Germany after World War II, complete catastrophe, absolute loss of the entire war economy destroyed, but in the context of the Cold War, lots of efforts were made simply to rebuild. New politics, true, economic system not fundamentally different from what we had before. So you can see that you can have a shock to the system, but then the system comes back almost as it was before, not completely altered. The question is, what are the forces of true transformation? And I think here Paget's work and the idea that you must have multiple, multi-layered transformative change that can be small but together has major impact is important. One point that he makes, and that's for me, I think, a problem in my argument, he has shown historically that the linkage between these different processes of change were very often family linkages, intermarriages, same elites sitting in the churches and sitting in the councils of the cities and sitting in the corporate boards, right? That we don't have, maybe don't even want to have. So for me, the question is what else could be the glue that holds this together? And I think I end up in the end by saying that what we need to think through is how transformative change can happen through law, because the capitalist system is a legal system, so you can't just say we do this without the law, because then we miss the very foundation on which it has been built. I think the change has to be incremental, and incremental change can, of course, also happen without necessarily having formal legal change. So I don't think it's going to happen through the legislatures. We all know that Congress is not the most effective institution, hasn't not even been just before the new administration. So we have to think about where else can it happen, and to some extent we can take a page out of the book of Capitalism, because they have engineered a lot of incremental change without a formal change in the law. One can exploit the gaps and openings and reinterpret the law, and people are quite creative about it. Think about rights of nature, think about new ways of using trust law to lock in the mission of a corporation, etc. we can also enable change by giving more collective, more power to collective groups to do something that probably would require some more institutional change. But the common denominator is really where I want to come out and where I'm coming out in the book, for better or for worse. I think what we've missed for so long, and I think what we have to reinvigorate, is really the normative agenda of what do we want and where do we want to go. And it can be as minimalistic as saying decentralization against a system that has become so centralized in private law. It can also be more, and I'm invoking in the book the ideas of individual capabilities that Amartya Sen and Martha Nussbaum have developed. The idea that every person, every human being has the right to live the life that she or he has reasons to value, and to think about how institutions would have to be reconfigured, applied, and enforced to live up to that kind of principle. And so if we screen our own legal system on that basis, we can, I think, begin a process by saying these are really impediments to this, and this is how we would have to change certain outcomes to make sure that every person has the right to live the life that they have reason to value. So with that, thank you very much. I'm happy to take any questions that you might have.
Hello, thank you. So I was thinking while you were speaking that how much I value so I care deeply about non-discrimination, equal access to resources, to the law, et cetera. And I maybe naively think that corporations, through things like corporate social responsibility, ESGs, have been better serving the people in many ways than the government has been in serving the people. And so, not that capitalism can save us, but I do see I wonder where, as soon as we make people do the right thing, it's no longer, they won't do it, right? So it's how can we corporations, law firms, whatever, they donate and do philanthropy because it's good for their capitalist agenda and maybe the right thing to do, but would we legislate corporations and capitalist structures to do better? I worry about that part. Yeah. And so I wonder if you could comment on that.
Yeah, so my strategy is rarely, if ever, saying top-down legislation and tell people what to do. I think that's also an issue that I have with some of the progressives in general, that they think the state can be the saver, and I think the state has always been the enabler, and it's not necessarily the saver. I also, as I mentioned, I am in favor of decentralized decision-making, so maybe in my hearts of hearts, I'm actually a liberal, but a true liberal in the sense of, people should have autonomy and decide their own lives, but that also means that other private people should not be able to dictate to them what to do. It's not only the state, it's also private power. So on the corporate side, I think more generally in business organization, I think there's lots of things that can be done. I'm not so convinced by ESG as a major transformative change. But I do see a lot of experimentation with new forms of businesses. Of course, one, for example, is the public benefit corporation, but it's just one example. Even outside this legislative change that has promoted this a little bit, we don't have that many companies, but we have lots of companies that are trying to find new ways to organize their businesses. We have new forms of co-ops. We're using multiple different legal tools, limited liability companies, co-ops, trusts, to log in missions of companies. So the idea that a company is not only an ATM machine for its shareholders, but it actually wants to accomplish something in life. Yes, it wants to produce enough so that people can take something out for their own livelihood, but not necessarily maximize shareholder value at all other costs, but have a mission, create a market, produce a product. It doesn't all have to be do good stuff, but having a mission creates a very different type of company than just saying shareholder value maximization. I always like to point to Boeing as a company that actually I think that was broken by the idea that cost cutting is the most important thing because it enhances shareholder value, and look where they ended up, right? And of course the externalities that they produced along the way. So for me, it's much more trying to find new ways of a more pluralistic business organization world. And a lot of things are happening. They're not overwhelmingly in numbers, and it's very hard to get numbers on them. But I think when you also look at legislative proposals in different countries, there's a lot of, I think, ambition in trying to find new forms of doing business for different reasons. Yeah.
Thank you. This is really fascinating. What do you think, and I haven't read your books, but I want to now, about AI and the belief that many people have that the 8 people who are running the design for our future, that they have started to talk about that AI will benefit workers. It'll make their lives more interesting. It won't eliminate jobs in the numbers that critics are worried about. But it seems to me that there's a lot of evidence that behind closed doors and privately that they're trying to drive their marginal costs to zero. Mm-hmm. And so how do you see a future with AI, if that is their design, where we would be able to create something post-capitalistic?
Yeah, I mean, I think the first thing that always irritates me a little bit is the term artificial intelligence, because it seems to be something, how can you not want more intelligence? How can you not want more things easier? Other people also have introduced sort of the idea of these are really, data systems and control over data systems. And I associate, therefore, AI also very much with sort of new systems of social control. It's kind of the coded power argument that I made before. If you come from that angle, you are kind of skeptical of an argument that says, oh, we know what is best for you. We can write the algorithms and sort of, and then you will find, then it's basically the rest is propaganda in my book, is to try to sell the model to others. Unless there is clear transparency, and not only that, but participation in how we design these systems, I fundamentally do not trust them and would also not trust this argument, and I'm not very in favor of having a handful of people dictate the lives of most others, not now, but also into the future. And I think what we've seen so far, there's an interesting argument that's very often made that historically we could say technological evolution has usually also created lots of new jobs, right? It has destroyed some, and there are transitions that you have to go through, but otherwise we don't have progress, so we have to live with that. We can find social security to make it bearable, but that's what's happening. I think this is a qualitative change from this. And even if there are still a lot of new jobs, I think the cost of the system, if designed in the way it's currently designed, outpaces the benefits and of a couple of new employments. Because I think it's fundamentally going to transform the way we work, the kind of controls we have over our work, and also the way we live.
Thank you again for joining us today. I know at the end of your presentation you talked about the shared normative values and goals. How do you think we should be getting there? Is that through the courts telling us what to do? Is that through the executive branch, the legislative, ballot box? Just would love to hear your thoughts on that.
Yeah, so I think, I want to start at the very basis, just to also reinforce the idea that what we do to one another and how we behave in relationship to others is really critical. And that's why I also bought into this idea of these capabilities approach. It has also, the beauty of this is that it's not so far removed from our ideas of individual rights, so people can relate to it. It's not completely alien. There's some literature in the law and development literature that talks about the magnet effect. So if you create sort of an aspiration for what people should do that's too far away from where they currently are, it's just not going to happen, because the people will just resent it, and especially the powerful in the community will resent it. But if you say it's actually not so different, right, capability is not so different from our individual rights, but it actually always says you can't exercise the right if that means that you actually deny others the same right to do the same. Okay, so that's the principle. And then, of course, the question is, how do you do this? I think you could already empower people in contractual relations, saying, but you can't do this to me because you're doing this to me. You would have to advance these arguments in court or arbitral tribunals. I think ideally, of course, we would have something bigger, right? A colleague of mine, Martin Hesselink, who's at the EUI in Florence, in response to the Code of Capital, he suggested that we should create like a European code of conduct for private law. It's basically sort of and enshrine these principles of social justice in a soft code of conduct. Now, you can have different opinions about codes of conduct and soft codes in principle. It would be one step that would basically elevate the whole thing from just in bilateral or maybe multilateral at the micro level to some principles. The problem with it might be is that we just think then we are done and leave it to the rest of the mech. But these are, I think, the steps that one can think through more systematically. If you then really want to go into institutional reforms, I think that one has to think about more participation in adjudication on issues that really have major normative implications that actually change the law. I don't think this is just legal interpretation. So the question is, could we have more direct participation, right? Like a kind of a jury system, but differently configured in these kind of decisions. That, of course, would require legislative change, and I think the legislative change typically comes on the end. It doesn't come at the beginning. You can't win these legislative battles unless you have people behind you and you have already proven in principle that this is possible and makes sense by trying to do this in a more bottom-up fashion.
Question?
So I have a little question about the line that you mentioned that the capitalism is based on law, with the consideration that law enforcement is required for the practice of law through the state apparatus, and that this creates a circle that enforces the cooperation between the state, the nation state actually, and the law system. So on that ground, I am curious how you would justify or explain a bit more how the code of capitalism is based in its law, but not in a more interactive way.
So I'm not sure I fully understand. So you're asking me how the code of capital, why I make this argument that capital is coded in law and that law is so important rather than
Yes.
driven by social norms, for example. What is the role of formal law rather than other types of social norms or social relations? Is that correct?
Yeah.
Okay, it's a very good question, and I think there is also big literature, and in part I have contributed to this as well, that we should not overstate the role of law. Law has very often also been used as a social engineering device, especially as we go to other countries and tell them adopt our laws and then you shall be fine, which rarely works because the laws that you then adopt or put in place are not necessarily congruent with fundamental social norms and preferences or groups within these societies and are very often rejected. I've written about the transplant effect many years ago and stuff like that. So I think we have to recognize the importance of social norms. I think for the system of capitalism, the amount of wealth that has been created, for me, is difficult to explain unless we understand that it is ultimately protected by our collective means of coercion and the legal system that gives legitimacy to creating capital in a certain way. So again, if we can of course have land, and we can have certain rules, we can have access to land at different points in time. But if I want to have the pecuniary money return of this land, I want to be able to exclude everybody else. And I can do this through physical force, but that's costly to me. It's much cheaper to rely on a legal system that says you're registered, you have the title, and you can call in the police or the bailiffs to remove everybody else. You basically socialize the cost of your property rights. That's huge. So this is how we use social resource to create private wealth, because you do not have to pay for this, right? In other ways, if you think about investment, shareholders do not ever cover the externalities that the firm creates. The firm might go bankrupt, but the shareholders at that time might already have recovered their investments. So we're creating legal systems and legal privileges in the form of limited liability, but that actually you could call a license to externalize. These kind of things don't have a clear mirror image in the social norms, and I think they can be scaled to national and indeed to global systems only because behind them are states that endorse and enforce these laws. Thank you.